So this is concerning Florida homestead property. And the comment says, so based on what you said, the homestead exemption survives the death of the owner, and the homestead property is not subject to liens or claims of creditors incurred during the lifetime of the deceased. Possibly. So, generally speaking, yes, but I just want to clarify a few points with this. So first and foremost, homestead property is a specific type of property defined in the Florida Constitution, and it does matter who the homestead property is passing to in order for it not to be subject to creditor claims. So as an example, if you own a primary residence in Florida and it qualifies as your homestead and you pass away leaving it to your children, then yes, a credit card company who you owe money to can't force the homestead property to be sold and the bill paid, or maybe some small claims lawsuit that you have, or any number of examples of just regular sort of creditors that may be out there, medical bills, credit card bills, loans, things of that nature. They can't force a family member, a direct descendant, to sell the property and pay off the debt. They also can't put a lien on the property. Alternatively, if you're giving homestead property to someone who you're not related to, and I see this most often in an instance where there's a couple who live together in a house that's owned by one of them. They're together, but they aren't married. And when this happens, the property, when it passes from the owner, say they left it to their significant other in a will, or something, or maybe they didn't, they left it in a will. They said they want my significant other to have my property. If it passes to the significant other who they weren't married to, it loses this qualification as homestead. So in this instance, it wouldn't be able to go through a probate process as homestead property because they are not passing the property on to a direct descendant or some blood relative of theirs. So this is sort of an important distinction. It does depend on who the homestead property is going to. Another thing I do want to bring up is this is true for almost all creditor claims, meaning if you are leaving your property to your children or to someone within your bloodline, then yes, you're not going to have to worry about selling the property. They're not going to have to worry about selling the property to pay off credit card bills, loans, all these other things I was talking about. However, if the property has a mortgage associated with it, it doesn't mean that the mortgage goes away when the property passes to, say, your children in the example that I was using. This mortgage does still have to be paid off. So the child or the children would have to either assume the mortgage or refinance. Usually a child can assume the mortgage if they're not able to refinance, but they would have to continue paying that mortgage. And if they're not able to, they would unfortunately be in a situation where they would most likely need to sell the property to pay off the mortgage. So the mortgage always follows with the property. Also, if there was some type of remodel done to the property and a general contractor or subcontractors were not paid for this service, they are permitted to put liens on the property. And again, these liens do follow the property. So you always have to figure out a way to pay back the GC or contractors that work on your home. If not, they can put a lien on the home and it will follow the property. So it's either going to have to be paid off by the new owner or paid off during the sale. And I also always like to mention it's never a good idea to try to avoid paying the IRS. The IRS is sort of a special creditor who can attach to most property, and in most cases, this would include or could include homestead property. So if there's a bunch of unpaid tax bills, back taxes, you didn't pay the government, you didn't pay the IRS federal taxes for many, many years, there's also a possibility that they could put a lien on the property. So there are a limited number of creditors. That's basically almost it though, really. So we're not looking at things like, again, credit card bills, medical bills, loans, even maybe something you owe as a result of a dispute. Most of these people aren't going to be able to collect from the homestead, again, so long as you are passing that down to a relative and you're not leaving the property to a friend or, again, a significant other who you weren't married to. Okay, so I hope this answers the question. If there's any other questions regarding homestead property or anything to do with estate planning, asset protection, elder law in general, and you're in Florida, please don't hesitate to contact us or atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.